Thank you. In 2013, the Supreme Court of Korea rendered an interesting judgment on the confiscation of a building used as a brothel. The defendant had covertly run a prostitution business for 1 year in a 5-story building, earning $150,000 in total. According to the Korean Criminal Act, a thing which has been used in the commission of crime may be confiscated. Although confiscation is not required in all cases, the court held in the case that it was legitimate to confiscate the building itself, taking into account the amount of proceeds, the net worth of the building, his criminal record, etc. Moreover, the court decided that the defendant should forfeit the proceeds generated from arranging sex trafficking. A few decades ago, the Korean government believed the most effective way to control organized crime was cracking down on specific crimes committed by organized criminals. For example, in 1990, then Korean president declared a war against crime, strengthening a crackdown on various crimes, including narcotic crimes, organized violence, and human trafficking. Moreover, organizing a group with the purpose of committing a crime was itself deemed a very serious crime. According to the Criminal Act, a person who organized a criminal group or who joined such group was supposed to receive the punishment specified for such crime, even when such crime was not committed. And the Special Act on Punishment of Violences provided that the leader of a criminal group organized with the aim of committing violent crimes was subject to death penalty or imprisonment for life or at least 10 years, even without any specific crimes committed by the leader or his or her members. For its principal members, the punishment was imprisonment for life or at least 7 years. And for the rest members, imprisonment for at least 2 years. For sex trafficking, another special act imposed the same punishment as the previous special act on the organizing deed of a criminal group aimed at committing sex trafficking. If you ever consider organizing a criminal group, maybe you should not do that, at least in Korea. As for property used for crime, a criminal act stipulates that a court may confiscate a thing which has been used in the commission of a crime and a thing which was sought to be provided for a crime. The main role of the Korean judiciary then was meting out harsh punishment to the criminals and exerting confiscating power in line with such strict legislative and administrative measures. The strategy was regarded as effective to some extent. Some of May's gangs collapsed, and some felonies, such as murder, rape, decreased by 6% in 2 years during the war against crime. The Criminal Act and those two special acts which entered into force in 1953, 1961, and 2004, respectively, are still in effect, with minor revisions made. As economic growth, economic profit has been the prime reason for modern organized crime, the global community has become more aware of the importance of preventing a criminal group from keeping criminal proceeds. Several UN conventions were signed, and the Korean government adopted corresponding measures with those conventions. As you are well aware, the United Nations Convention against illicit traffic in narcotic drugs and psychotropic substances of 1988 stipulates that each party shall adopt measures to confiscate proceeds derived from narcotic crimes or property worth such proceeds. A relevant Korean act, Special Narcotics Act of 1995, provides that proceeds generated from drug crimes and property obtained from the proceeds are subject to confiscation. The Act also focuses on preventing money laundering, saying that anyone who accepts those proceeds, knowing them to be illegal profits, shall be punishable. In furtherance of mutual legal assistance, the Act stipulates that the government may cooperate for the execution of confiscation by the request of other countries. After the United Nations Convention Against Transnational Organized Crime was adopted in 2000, another special act was enacted in South Korea. The contents of the act with regard to confiscation, money laundering, and mutual legal assistance are similar to those of the Narcotics Act I just mentioned, but the former expands its scope of application to a variety of serious crimes beyond drug crimes. On the other hand, before the United Convention Against Corruption was signed in 2003, the Act on the Aggravated Punishment of Specific Crimes had already put stringent punishment for bribery. The Act is still in force. The amount of the accepted bribe is over $80,000 US. The penalty is imprisonment for life or at least 10 years. Between $40,000 and $80,000 US, imprisonment for at least 7 years, and between $25,000 and $40,000 US, imprisonment for at least 5 years. In addition to the punishment, the bribe is subject to confiscation pursuant to the Criminal Act. The activities of organized criminals in South Korea involve loan sharking, prostitution, drug smuggling, extortion, illegal gambling and gaming, stock manipulation, etc. Organized crime is largely motivated by criminal proceeds as well in South Korea as in any other country. The necessity of forfeiture of illegal profits has been well recognized in the Korean judiciary. The confiscation of criminal proceeds has not aroused much controversy in that the profits are generated from the criminal deeds, and therefore there is no legitimate ground for the criminal to hold the profits. The punishment of money laundering has also been less controversial, as the measure is considered an effective means to enforce the forfeiture of criminal proceeds. The confiscation of property used for a crime, however, has often been the subject of debate. As I just said, a court may confiscate a thing which has been used or was thought to be used in the commission of crime. This type of confiscation can sometimes be excessive infringement on the right to property, especially where the value of a thing used for offense is disproportionately bigger than the value of profits or utility obtained by the offense. A building provided for gambling or a car used in drunk driving could be such an example. The principle of proportionality applies here. The Supreme Court held that all the relevant factors, including the following, should be considered in deciding the legitimacy of confiscation: how a thing was used in the commission of crime, how essential the thing was for the commission, how big the victim's damage was, the role and responsibility of the owner of the thing, the motive of the offense, and the possibility of recidivism. The recent judgment I mentioned at the beginning applied the principle of proportionality. As presumed in the case, the confiscation of property could be effective for the deterrence of crime. It is judge's duty, however, to strike a balance between meeting criminological purpose and protecting the property right, just as a criminal's right to due process should be protected even when harsh punishment is inflicted. A controversial Anti-Corruption Act will enter into effect this September. The Criminal Act and the Act of Aggravated Punishment of Specific Crimes limit the scope of punishment of corruption offenses to public officials and staff of public organizations. The new Anti-Corruption Act expands the scope to journalists and teachers, and the government is now considering promulgating its relevant enforcement decree, which levies a fine against a person who receives a present worth of $40 regarding his or her job. This legislative effort seems to reflect the public's desire for stronger legal measures to enhance the integrity and transparency of the society. The Korean judiciary will accordingly continue its effort to impose strict punishment for organized crime and to confiscate illegal profits and property used for offense, but not at the expense of the defendant's right to procedural justice and property. Thank you.